sorry if we've kept you waiting with our systems difficulties, but hopefully everything will now be working.
My lords, my lady.
Thank you.
My lords, my lady, have my lords read the written case that we have filed?
Yes.
Now, my lords, my lady, in the light of the submissions that have been made by my learned friend, in actual fact, I can shorten my submissions quite considerably.
Well, I think we certainly, for our part, would welcome your submissions on the law. There are some issues which are raised in your case, which are, or at least may not be thought to be, completely straightforward. In relation to, for example, bona fide purchases without notice, and also in relation to rectification. And certainly we would welcome your full submissions on those two issues.
My Lord, as your Lordship pleases. My Lord, in relation to my first submission, which is the trusts, including constructive trusts imposed by the courts, are an exception in the Montserrat legislation to the principle of indefeasibility. And your Lordships have got to bear in mind that with all torrent systems, there was always a balance between certainty and doing justice. And those were the observations of the board in the BVI case in Arthur, and also of the board in the BVI case of Santiago Castillo. Now, I don't think that it's disputed in this case, in fact, because I've not heard any submissions from my learned friend to that effect, that constructive trusts actually are an exception in the context of the Montserrat legislation to the principle of indefeasibility. And in fact, your Lordship will be able to find that Arthur at page 1164 and the paragraphs that I rely upon, the paragraphs 2, 31, 43, sorry, paragraphs 3, 31, 43 and 44. Now, I don't intend to take your Lordships to this authority because it does not appear to be in dispute.
This is Crack and Pen.
I beg your pardon. This is page 999.
Oh.
That's Arthur. And likewise, it does not appear to be disputed that, in fact, personal or claims in personam, be they claims at common law or equitable claims, that those exist outside the principle of indefeasibility. In other words, they don't infringe the principle of indefeasibility, and the authority for that proposition, in the context of legislation that was almost identical to the legislation that we are considering today, is the authority of Crack against Pen of the board.
And which paragraphs in that?
And your Lordships will find that at page 1164, paragraphs 9, 12, 13, and in particular 14. I should have also said that in relation to Arthur, which is on constructive trust, that legislation is BVI legislation, that too is legislation that is almost identical to the legislation that we are considering today. And therefore, my lords, just making.
But that's in very broad terms, because as I understand the Arthur decision, it's directed to the principle that a person who has knowledge that a transfer is in breach of. I beg your pardon. That if there is a transfer in breach of trust.
My lord, that's
which
because
one has knowledge?
The context there was a constructive trust case, and therefore knowledge of the breach of trust was an essential prerequisite in relation to that.
Yes.
But the principle is of general application. In other words, the court, looking at the scheme of the legislation, took the view that actually constructive trusts were an exception to the principle of indefeasibility.
When you say that they are an exception, there are two things here. One is whether if the title is registered and then an innocent third party acquires the land from, say, the appellants, does the exception that you posit mean that they somehow do not acquire good title, or does the exception only prevent the appellants from acquiring complete legal and equitable title?
Essentially, they would acquire legal title, but they would hold on trust on behalf of the transferee in this particular case. In our case, it would be Pell.
Transferor, yeah.
Transferor, I beg your pardon. Transferor would be Pell. So essentially, a constructive trust would arise that is a proprietary. In other words, you have legal title, and they hold legal title on behalf of the transferor. And that is the decision, in my respectful submission, in Arthur, and in particular paragraphs 43 and 44. Do my lordships want me to take them to that? But I haven't heard anything from my learned friend that in fact, having read our submissions, that in fact this is something that is in dispute.
But then what does happen if one of these appellants had sold the land on to someone else?
Well, then if essentially you have a bona fide purchaser for value acquiring the title, that would essentially extinguish any right that Pell would have to the property. That's essentially.
So the principles are just the same as any other constructive trust operation?
Yes. Yes. And the question, of course, is on my alternative case. I don't even need to get to my alternative case, because I think my learned friend accepts that in the circumstances of this case, based on Brelsford and also based on the decision in Gibbs versus Mercer, that a personal equity arises. Well, my alternative case is posited on the basis that I beg your pardon.
Certainly, for my part, I would welcome submissions on the question of whether or not there is a personal equity and what you mean by that. But you'll come to that. So I just wanted to pull you up insofar as you were assuming that there was nothing between you and your opponent might also apply to the court.
But I understand for this point that when you describe it as an exception to the principle of indefeasibility, you accept that it can't survive, your equitable interest cannot survive the transfer from the appellants to a bona fide purchaser.
For value, yes. Value. I accept that.
Without notice.
Yeah.
Yes, but, my lady, I say it's an exception because, of course, the proviso in section 23 refers to trusts and the duties of a trustee. That's a proviso. That proviso existed also in the BVI legislation in Arthur, and on that basis and the construction of the legislative scheme as a whole, which is for intents and purposes identical, I say, the court there took the view constructive trusts are an exception to the principle of indefeasibility, and in fact that the legislature in Montserrat has decided to strike the balance between certainty and the interest of justice by allowing that exception. And I rely on the decision in Arthur. Now, my lady and my lords, may I therefore take your lordships want me to address them on...
Your proposition is that there is a constructive trusts are an exception to the indefeasibility rule, and I certainly from my part would like to know how this is a constructive trust.
Yes.
Yes, let me take that. Let me take these points first, and then let me then turn to Brescavar and also to Gibbs. Now, the only reason why we say that, in fact, the Court of Appeal did not at the very least consider a case on the basis of constructive trust is because they felt constrained by Australian and New Zealand authorities, and of course they didn't have the benefit of Arthur when they made the decision. And I say that because at tab 40, page 309, paragraph 52, your Lordships will see that the Court of Appeal relies on Asset Company Limited, and they say the nature of the equity that arises in favour of the displaced proprietor under void transaction, as the Court of Appeal took the view that this was a void transaction for lack of authority, they said was considered an Asset Company Limited, and Lord Lindley concluded, then it's contended that a registered owner may hold as a trustee and be compelled to execute the trust subject to which he holds. This is true, for although trusts are kept off the register, a registered owner may not be beneficially entitled to the lands registered in his name. But if the alleged sequi trust is a rival claimant who can prove no trust apart from his alleged own ownership, it is plain that to treat him as a sequi trust is to destroy all benefit from registration. Here the plaintiff set up an adverse title, nothing else, and to hold in their favour that there is any resulting or other trust entitling them to the properties in their Lordship's opinion to do the very thing which registration is designed to prevent. And then at 53, and we pick it up just below the middle of the paragraph, where he says, he did not hold it on trust for the appellants, but as between themselves and the first respondent, they had a right to sue to recover the land and to have the register rectified. Their ability to make such a claim being within section 124D. But as the trial judge correctly points out, such a claim is an equitable claim enforceable by reason of the principles of the Court of Chancery. The appellants require the assistance of the court having equitable jurisdiction. And then at 54, the void transaction therefore does not give rise to an equitable interest in the property itself, but could give rise to an equitable right to sue for recovery of the land, and the appellants, as the new registered proprietors of the land, would hold their title subject to this right. And it appears the Court of Appeal appear to have essentially come to the conclusion that in my submission, that trusts or constructive trusts were excluded. And in fact, my lord, my lady, at paragraph 12 and paragraph 13, the Court of Appeal...
Sorry, I do apologise. Why was it not held on trust? What are the facts of that case that meant that it wasn't held on trust?
Which ones, my lord?
Well, the first one, Assets Company Limited.
My lord, all of these cases actually can be if they were decided today, or if they would be decided under English law, yeah, I dare say Montserrat law, they probably could be justified on the basis of a constructive trust, because what you're dealing with is a fraudster, and you're dealing with recovery of the land from the fraudster. So in the same way that there is an equity as against the fraudster, because the fraudster has taken your land, a constructive trust would also arise in those types of cases.
Well, for my own part, I've got no difficulty about the fraudster holding it on the basis of a constructive trust. But here is different, of course. It's the purchaser from the fraudster that is holding it on a constructive trust.
And this is why I made the point to my lady when she asked me the question, that actually, I'm coming to this submission in a moment, that when you start drilling down into these facts, the way that this has been handled by the lawyers, one of the lawyers was a claimant as well, in failing to make any inquiry whatsoever, in the way that it was handled, in not essentially those lawyers not being put forward to give evidence at the trial. Actually, this is a case of a deliberate decision not to make those inquiries. And if this is a case of a deliberate
finding
decision...
to that effect.
My Lord?
That's not been found.
My Lord, the judge at first instance, if I may take your Lordship to the decision of the judge at first instance. So if we look at...
Perhaps you kind of... What are the propositions of fact, then, that you say have been found here, in a nutshell? You say there has been a finding of willful shutting of eyes.
Well, no, but I say that the facts as they have been found by the judge do justify that inference, in my view, or at least the finding that the conduct of the appellants has been unconscionable, and that is what I need to establish. This is not a knowing receipt type trust. What we're talking about is Lord Brown Wilkinson's decision in the House of Lords in Westdeutsch, where essentially he talks about unconscionable conduct.
So which is the finding you rely upon?
Yeah. My Lord, all the findings that I drew your Lordship's attention to earlier, and what the judge also says, so at 68 he talks about the balancing of the equities at 68. The doctrine of notice lies at the heart of equity, given that there are two innocent parties, each enjoying rights. Earlier rights prevailed against the latter right if the acquirer of the latter right knows of the earlier right, actual notice, or would have discovered it had he taken proper steps, constructive notice. And then third line from the bottom, such other steps as are reasonable to verify whether such earlier right does or does not exist, he will have constructive notice of the earlier right, that of Pell, and take subject to it. In dealing in matters of business, this is what he says, in dealing with matters of business, regard is had to the usual course of business, and the purchaser who wilfully departs from it in order to avoid acquiring knowledge of his vendor's title is not allowed to derive any advantage from his willful ignorance of defects, which would have come to his knowledge if he had transacted his business.
He's just setting out propositions of law derived from...
He is. Well, he is. But he is. It has no relevance unless he also has in mind that here what we have is at least a willful departure from conducting those searches. Now, my lords, there are very limited explanations here as to why the lawyers did not conduct the searches. Now, in circumstances, I'm going to drill down on that in a moment. But in circumstances where those lawyers, where they're not put forward to give evidence to the court and say, well, look, the reason why I didn't do this is because I was careless or I had a bad day. Why should we be giving the benefit of the doubt to the appellants or the lawyers that actually this was just simply a deliberate decision that had been taken?
You don't need to go there. As far as I understand it, your argument's based upon constructive knowledge and unconscionable conduct.
Well, indeed.
It doesn't have to extend to deliberately closing their eyes. That was a factual finding that could have been made, but certainly I can't find it having been made.
My subsidiary submission is the point that my Lord makes to me, which is actually when you take all the facts into account in this case, this is a case of unconscionable conduct, and therefore that a constructive trust does arise.
But it can't just be unconscionable conduct. I mean, people sadly behave unconscionably towards each other all the time. It doesn't entitle everyone to set aside land transactions. There has to be, at the kernel of it, a cause of action. Now, I thought you were going to say the cause of action here is that there was a void transfer because, in fact, Mr. Castle did not have the authority of Pell to transfer the title. So is it that your equitable claim arises in some way out of the voidness of the transfer, and then you get onto the question of unconscionability and notice, not because that founds your cause of action, but because that prevents them from raising a defence that they are a bona fide purchaser. But it's that prior step that I think I'm searching for at the moment. What is it that...
It's in the alternative, in actual fact. It's in the alternative. Now, Goff and Jones, in their book on the law of restitution, they posit the fact that lack of consent, want of authority. In this particular case, we know from the Court of Appeal that the Court of Appeal held quite clearly that the dispositions were void, and that's the reality of this, the dispositions were void. That does give rise, in those circumstances, to a constructive trust. There is an alternative basis for a constructive trust, and that is on unconscionable conduct. And of course, the question is whether, on the facts of this case as a whole, whether there is unconscionable conduct.
And just tell me again where this alternative basis of something just arising from unconscionable conduct, where that comes from. And do you go so far as to say that even if Pell... I mean, if Pell had got authority, had given Mr. Castle authority to transfer the land, then presumably no amount of unconscionable conduct on the part of the appellants would enable you to get the land.
None of this would arise, no, absolutely. But
also, why is that an alternative basis from the voidness of the dispositions?
My lady, the fact that we are dealing with, the fact that essentially you're dealing with a company, the fact that you've not made any of the inquiries that it was your duty to make to ensure that you are in fact dealing with that company, the fact that as a consequence the underlying land transfers were void.
Who's the duty owed to?
The duty, the statute clearly imposes a duty on you, on the purchaser, essentially. Well, there are two ways. One, there is a duty. When you deal with a company, you're buying property from a company, you've got to ascertain that you are dealing with that company, and companies operate through human interveners, and therefore you've got to make sure that the person that is in front of you has the authority. In this particular case, the judge held, well, if you had conducted the most basic rudimentary inquiries, you would have seen that that was not the case.
And is this a fiduciary duty, or is it?
No. It's a duty on the party in ensuring that you are dealing with the person that's in front of you, the company, and that the company has authority.
But it's not a duty owed to the company.
It's not a duty owed to the company. No, I accept that it's not a duty owed to the company. But in fact, when we come to look at the structure of the Act, we will see that quite clearly it proceeds on the basis that there are various requirements that need to be satisfied in order to make sure that both parties, sets of parties, are protected.
But if Mr. Castle had been authorised by Pell to do this, then the solicitors for the appellants could have been just as neglectful in failing to make any inquiries, but your case wouldn't have got off the ground simply based on their neglect to make those inquiries. It's only because, in fact, he didn't, and that the transaction was void, that you have a claim, isn't it?
But, my lady, if the solicitors had been authorised, in other words, if Mr. Cassell had been a director,
yes,
then there is no question of the other party essentially doing anything. Well, they could have done something wrong in the sense that you are required essentially to make those inquiries to ascertain. But of course, the transaction would not have been void, and there would be no question of any constructive trust arising because the property would just simply pass.
I mean, is your submission, as I understand it, that there are various alternative ways of looking at this? We're trying, as I understand it, to pinpoint what the Court of Appeal meant when they said there's an equity. And as I understand it, you're saying try and link that back to understandings as to what equity might be doing here, and that drives us to a constructive trust. Then you say, and constructive trusts are outside the Torrens system. Now we're trying to pinpoint what are the different grounds for constructive trusts, as I understand it. At the root in all this is that there's a void transaction, so there's want of authority, and you say, Goff and Jones, you may struggle to give us authority on this, but anyway, Goff and Jones say that is enough for a constructive trust.
Yes.
But then if that's not right, you need the void of transaction plus something on top, which you might say is constructive notice per se, or you might extend it still further to say constructive notice plus deliberate, almost wanton lack of notice. I think the third of those is probably ruled out on the evidential findings, but I think that was your submission. But both of those would fall within a sort of rubric of unconscionability, I would suspect. Is that how you submit it?
The latter two, yes.
Yeah.
The latter two, yes. And in fact, I don't need to go as far as to say that there's been a deliberate and willful, essentially, Nelsonian blind eye knowledge. In other words, what perhaps your Lordship might recognise, bad number 2, the third category, where Peter Gibson, Mr. Justice Peter Gibson says, willful or reckless.
Yeah. But I think this was the point my Lord Hamlin was putting to you, that the paragraph you took us to seemed to be as if you were steering towards that, a sort of Nelsonian shutting of one's eyes, but I'm not sure you are doing that.
Yes, yes. And then, of course, at 71, well, I'll take you, Your Lordship, back at that, to that.
Sorry, where are you now? 71 of the judgment.
247.
Yes, it's 247. In my opinion, prudent business practice dictates that when someone is purchasing from a company, inquiries must be made by way of conducting a search at the company's register to ascertain the standing of the company, the officers authorised to transact the business of the company, and the manner in which the authority of those officers is to be carried. I find, therefore, that as a matter of law, in the circumstances of these cases, several claimants, having not, as previously found, made any such inquiries, have constructive notice that Pell did not consent to any of the land purchases, and therefore they take subject to Pell's right. This is sufficient to find in Pell's in favour of Pell. However, counsel for the claimants in his submission seek to rely on the indoor management rule. Now, my lords, in this particular case, there was no doubt that everybody, the appellants all understood, the claimants understood that what Mr. Rooney was saying is there was a lack of authority, and there I would draw your Lordship's attention to tab 6 at page 110, which is the skeleton argument.
This is the skeleton argument of whom at what level?
For the claimants. Skeleton argument for the claimants just before the trial. And your Lordships will see the defendant's case. This is what the claimants say about the defendant's case. The case for the defendants, second paragraph, so it's a second substantive paragraph of that section. The case for the defendants, as foreshadowed from the defence, appears to be 1. Warren Cassell, the person responsible for conducting the sale of land on behalf of the first defendant, was not a director of Providence Estate Ltd and was not authorised to sell lands on behalf of the first defendant. 2. The claimants ought to have known that Warren Cassell was not authorised to transact sales on behalf of the first defendant. This is all the claimants understood the case to be put on that basis. Now, one of the remarkable features of this case is that despite the way the case has been put against them, they neither pleaded a response to this. In fact, they never pleaded a response to the claim for constructive trust, which was pleaded. Unjust enrichment was pleaded. The Court of Appeal, paragraph 17, said, well, rather strikingly, there was no response to this. nor did they file any evidence to deal with any of these points. What the appellants chose to do is to stand behind a defensive line based on three arguments. The first was that Mr. Cassell was openly conducting sales on behalf of Pell. Secondly, that Mr. Cassell was a lawyer and they were dealing with a lawyer. And thirdly, at no point did it occur to them that Mr. Cassell had no authority. That's essentially the height of the claimant's case. Now, it's not surprising in my submission, therefore, that the judge found that no inquiries had been made, and that all the documents showing that either the company did not exist at the time four of these appellants, 6 to 9, signed the instrument of transfer, which is the document, as I said, which is accepted by the registrar, or showing that Mr. Cassell was not a director, were public documents, and that they were easily accessible. Now, not only, essentially, did they not conduct, the lawyers did not conduct these searches, but actually, I'm now going to take your lordships to the relevant section, section 106, 7, 8, and 12. And as you will see, there are very significant breaches of those provisions. So may I ask your lordships to look at. So tab 54. The Act starts at page 861. And the first section is section 106.
Which is on page?
Page 909.
909.
And 9. All of the points I'm going to be making now are going to be relevant to the rectification arguments in relation to section 140. All of these points.
Is that relevant to both arguments or only to rectification?
Relevant to rectification and also relevant to the points that I'm making now.
Constructive trust.
Constructive trust.
Yeah.
Yes, exactly. Now, my lord, if one looks at section 106, your lordship will see that every disposition of land, a lease or a charge, shall be effected by an instrument in prescribed form. And then at subsection 3, your lordships will see instruments shall contain a true statement of the amount of value of the purchase price or loan or other consideration, if any, and an acknowledgement of the receipt of the consideration. And if we look at page 936, we see the prescribed form there. And your lordships will see that we, in consideration of, the receipt hereof is hereby acknowledged. So in other words, the transferor of the land acknowledges receipt of the consideration. Here we know, from the findings that the judge made, don't think this is seriously, can be seriously disputed, that Pell never received any consideration at all. But of course, the section is designed to ensure that the owner of the land receives the consideration. And if we look at section 107, go back to section 107, every instrument evidencing a disposition shall be executed by all persons shown on the register to be proprietors. Proprietors are defined in section 2, and your lordship will see that is at page 870, and proprietor means the person registered under this Act as the owner. Essentially, what we are, again, it's designed to ensure that the proprietor, it's the owner of the land, is protected in the way that I'm going to now show. So, then over the page, at subsection 2, subject to section 122, which is not relevant, of this Act, an instrument shall be deemed to have been executed only. So unless you comply, the instrument is not deemed to be executed. And if one looks at B, Roman numeral 1,
Sorry, I've lost the page again. I beg your pardon.
that's a page 910.
Thank you very much.
So by a corporation, so the instrument shall be deemed to have been executed only. Those are the words used, only. And then B, by a corporation, if sealed with the common seal of the corporation, affixed thereto, in the presence of and attested by a clerk, secretary, or other permanent officer, and by a member of the board of directors. And by a member of the board of directors. And I'm going to take your lordships to the transfer, to the instrument of transfer, because your lordships will see very, very significant non-compliance, indeed disregard, basic disregard for section 107, which is the point Mr. Rooney has been making throughout this entire court process. And then at 108, your lordship will see, subject to subsection 3 of this section, a person executing an instrument shall appear before the registrar or such public officer or other person as is prescribed, and unless he is known to the registrar or such public authority, public officer or other person shall be accompanied by a credible witness and shall produce a document or documents of identity. The registrar or public officer or other person shall satisfy himself as to the identity of the person appearing before him and ascertain whether he freely and voluntarily executed the instrument and shall complete thereon a certificate of that effect. Now, pausing there was no evidence. You see, the evidence of the lawyers as to what actually happened and what happened, for example, at the registry, all of that would have been relevant. But of course, there was a lacuna in the evidence here, and that lacuna was of the making, in my submission, of the claimants. They chose not to call Mr. Brandt. They chose not to call Mr. Carmarkham. Mr. Carmarkham is the person that was actually representing the claimants. And then we look at section 112. Your lordships will see, except as provided in subsection 3 of this section, no instrument executed by any person as agent for any other person shall be accepted by the registrar unless the person executing it was authorised in that behalf by a power of attorney executed and verified in accordance with sections 107 and 108. So it refers back. The original of such power of attorney, or with the consent of the registrar, a copy thereof, certified by the registrar, shall be filed. Now here there is no power of attorney. There is no evidence at all of any power of attorney. So any authority that Mr. Cassell may have had as agent on behalf of Pell would have been, if he wasn't a director, could have been as an agent duly appointed by the true directors, of course, but in this particular case, there is just simply no. Now, what I say about this is, the structure of this Act is, all these sections are designed to ensure, and have to be, I should say, have to be analysed in the light of the principle of indefeasibility. In other words, once you register, you're the registered proprietor. And what these sections are designed to do is to ensure that those that are buying and selling land are the proper parties, and that is done by going through certain hoops. In particular, section 107. Now, just let me now take your lordship.
Take me to, or could you explain to me, the actual documents that were lodged in the registry were lodged by Mr. Cassell's. Did the appellants play a part in lodging those documents?
Well, we don't know. That's the problem. We don't know.
Ordinarily, does the appellant play a part? Would the purchaser ordinarily play a part?
Well, the purchaser would, it appears from the structure of this Act, would appear to essentially go before the registrar.
Yeah. Okay.
So we don't know, you see, what essentially has happened, because the lawyers never gave evidence. Now, I remind you, Lordships, that Mr. Brandt was essentially convicted and imprisoned last year, but he was available in 2016 to give evidence. And so was Mr. Markham, who was there at the time representing all of the claimants, except according to my learned friend, Mr. and Mrs. Osborne, I think that.
Do we have in the bundle the
instruments of transfer?
All these instruments are then presented, and the people are presented to the registrar, and then the registrar decides whether or not to register the title. And here, at this stage, we're talking about the title that these appellants got.
We're talking about Pell's title.
No, we're not at this.
Pell's title's
No,
already been
Pell's title is, there's no problem with Pell's title. What we're talking about is
I beg your pardon. I
registration.
misunderstood the question.
Yeah.
Yes, we're talking about their title, yes.
Yes, we're talking about what needed to be done in order for these appellants to become registered as the holders of the title in this land. But do all these documents, in a normal case where there's no problem and everything is done as it should be, what actually appears on the land register? So suppose Mr. Castle had been properly authorised, there was no problem with this, they did all the... What I'm trying to get at is, this is leading up to the outcome of these appellants being registered on the land registry.
Yes.
But what we're talking about is what they should have seen on the register before that happens. Or it's not an inquiry as to the land register. It's an inquiry. Well, so then the question that my Lord Stevens then maybe is my question as well. What in an ordinary case would the solicitors of the would-be purchasers see, and from whom would they get it? Because it's not yet on the register, because we're in the process of registering their title. So how would they know whether all these things have been done that you've drawn our attention to?
It's their obligation to make sure, my lady, in my submission, it's their obligation to make sure that a transfer actually complies with Section 107. It's the party's obligation, both parties.
So the document at 936 requires to be signed by both the transferor and transferee.
Yes.
And
But it may well have been signed by Mr. Castle on behalf of Pell and signed by them. But what of all this were they supposed to inquire about and find out?
Let me take my lady to the actual documents themselves.
Yeah.
Having in mind, my lady, the requirements of Section 107. So, the Brelsford transfer, instrument of transfer, is not in the bundle. I have one here. I have the Brelsford one here.
Well, just before you refer us to that,
I don't know why it's not in the bundle.
is it a document that was before the Court of Appeal and before the judge?
No, it was before the judge, but somehow it's just simply been missed by whoever's composed the bundle.
Was it before the Court of Appeal?
Yes, it was before the Court of Appeal. That's my understanding. But let me start with Kraus. That's a page 162 of the bundle. Now, my lady will see, and my lords will see, that what we have is an instrument of transfer. It's in the form of the Schedule 3. It's dated the 11th of January 2000.
Shall I get you another liquid?
No, it's okay. Thank you very much. So it's dated the 11th of January 2008, and it's signed by a director. The director is not identified. It's not signed by a secretary or the other officers. And my lords will recall that it needs to be the actual seal. It's a seal that needs to be attested by a director and also either a secretary or some other official. There's only a director, and of course that's Mr. Cassell, we think, and that's an imposter director, essentially. Now, if we then look at
This seal above the director's name, is that a land registry seal or is that purporting to be the company seal?
Apologies. This is the company seal, the counterfeit company seal. So this is the company seal that is required by dint of Section 107. And it needs to be attested by a director and another official. And it doesn't. And of course, if you're a lawyer and you're acting on behalf of the Krausers, the first thing that you would do is you would say, well, hang on a minute, this doesn't comply with Section 107. If we then look at
Sorry, why doesn't it comply with 107? Did you say?
Well, because it is. You say because 107. If we look at Section 107.
Well, just tell me.
Essentially, a seal. It requires if you're transacting with a company, it requires the instrument of transfer has to be sealed with a common seal of the corporation affixed thereto in the presence of and attested by its clerk, secretary or other permanent officer and by a member of the board of directors. This is both. So what you have here is a document that, quite apart from all the other points that the judge makes about that they never looked at all the public documents in the companies in the register of companies, this is a document where the seal has not been attested by the second official as required by Section 107.
But it's not only not attested by, it's not in the presence of either. It doesn't declare it's in the presence of, does it?
No.
No, it says affixed thereto in the presence of and attested by. Both. That's Section 107.
Yes, but if you look at 162, it says it's signed by the director of Providence Estate Ltd in the presence of, so there should be the signature of the director and then the person in whose presence that was
Attested.
Yes, signed, in whose presence it was.
The notary public, looks like. The notary public.
Well,
But with these points
a
taken before the courts below.
Yeah.
yes.
They were.
All of these points were taken in the courts below. The notary public, Mr. Mr. Rooney put to the witnesses, is that Mr. Brandt's signature? Nobody could really appear to be able to take it much further. So we don't know who the notary public is, not identified. But the seal of the company is a counterfeit seal. It's not attested. It's not been fixed in the presence, not been attested to. And then if we then look at Osborne, and that is at tab 26, page 183. Here there is no seal. That's 183. There's no seal.
Here we've got a director and a secretary.
The secretary is Ms. Lynch, and she also has no authority to be the secretary because, of course, Mr. Rooney was the secretary at this time. This is somebody that Mr. Cassell essentially says, well, could you sign as secretary, essentially? But again, there's no seal. And then if we look at, well, I have Brelsford.
Well, we get the idea that you're saying that all these were defective in some way.
Exactly, my lady. But the point is...
You may also say, I suppose, that when you're dealing with a system, a tourist system of registration, it's all the more important that these formalities are adhered to.
Exactly. Yes, because of the consequences of the indefeasibility of title. What essentially the legislature is doing is it's saying, look, these are serious consequences here.
Yes, I think we understand your submission on that, yeah.
So you say that's a mistake within section 140, is that right?
We say that, I'll come back to 140 in a moment, but essentially with 140, where you have, the authorities say this, where you have a void disposition, and that void disposition is registered, there is a mistake in the registration process. That's what you need for section 140, mistake in the registration process. But you can have a mistake, an anterior mistake, in other words, essentially you've got a void disposition that then finds its way into the register, and it should not be registered. The authority for that is the English Court of Appeal case that I drew your Lordship's attention to.
Is that Antoine?
Antoine, indeed.
It just seems a very odd use of the word mistake when you're dealing with a fraudulent transaction.
One is not.
I don't want to take you out of your course. You're going to come to that, but I understand you're going to submit that is a mistake, and Antoine, you're going to submit supports you. But just before we get to, as I understand it, you're still making your submissions in relation to constructive trust. Is that?
My Lord, yes. So my Lord, so at paragraph 6 of the judgment, the judge records the fact that at trial it was conceded that knowledge of the solicitor is knowledge of the client. We say that where a party has a duty to investigate or at least comply with statutory provisions, it's a duty of investigation that you are essentially dealing with the correct, when you're dealing with a company, that at least the directors have authority by conducting the searches. And if you appoint an agent to do that, and he doesn't do it, then any knowledge that he would have acquired had he properly discharged that duty is also the knowledge of the client.
What are you reading from now?
I beg your pardon?
What are you reading from now?
Submission. No, I'm just from my speaking note, my Lord.
Oh, I beg your pardon. Thank you.
Now, my Lord, in this case, I said that they could have called their lawyers, and they didn't call the lawyers. Now, in relation to Brunt, and I want to start with the appellants represented by Mr. Brunt. Now, in fact, it was said during the course of my learned friend submissions that Mr. and Mrs. Osborne were not represented by Brunt in the underlying property transaction. That's not the case, and that is clear from the transcript at page 201, because the witness is asked and he says that yes, that he was represented by Mr. Brunt. Now, Mr. Brunt was in prison last year, but he was available in order to give evidence in 2016. He was the partner of Mr. Cassell, so he therefore had a close business relationship with him, which no doubt, in my submission, would have been explored by Mr. Rooney and would have been explored by the judge had he been called to give evidence. Now, I want to take your lordships to the Privy Council decision on the decision to overturn the conviction of Mr. Cassell. Certain observations are made that are relevant, and your lordships will find that at page 536.
This is Lord Hughes, is it? Yes.
Yes, this is the board's decision in 2016 overturning the conviction of Mr. Cassell on the grounds essentially that the conviction for conspiracy was unsafe and unsatisfactory. Your lordship will see paragraph 3, page 539. The Crown's evidence was uncontradicted and indeed very largely unchallenged at the trial. Cassell did not give evidence, and neither the defendant called any. Cassell made a relatively brief unsworn statement from the dock. The following essential facts were therefore not disputed. Cassell's interest in the development land was afoot by at least January 2007. On the 28th of January 2007, he made an attempt to contact Rooney and spoke to the latter's brother, who lived in Fairfax, Virginia. He told the brother that he wanted to discuss buying the land from Rooney. The brother promised to put Rooney in touch with Cassell, either when he heard of the inquiry or little later in the year when he learned that Pell land was being offered for sale. Rooney, then living in California, made contact with Cassell via his own Montserrat lawyer, Mr. Sargent. Your lordship will have seen from the correspondence Mr. Sargent is representing Mr. Rooney and Pell. At paragraph 7, your lordships will see Rooney's Montserrat lawyer, Mr. Sargent, contacted Cassell at the latest in July 2007. So in July 2007, Rooney's lawyers contacted Cassell. He explained that Rooney owned a 40% interest and was the director, and that he wanted to know why Pell's land was being offered for sale. He was told that Wood had transferred his shares. After this meeting, Cassell contacted Mr. Sargent with a series of offers to buy Rooney's interest. Some of those offers were made in writing in a letter of the 7th of September 2007. In that letter, Mr. Cassell asserted that when I had bought Wood's shares, the latter had said Rooney was either dead or avoiding him, although that assertion was scarcely consistent with Cassell's having opened contact with Rooney via his brother some 8 months earlier in January. A further open offer was written by Cassell on the 14th of September. Rooney did not accept any of these offers. On the 19th of September, acting through a different firm of Montserrat lawyers, Cassell made a claim on Rooney in the name of Pell for money which he alleged was owing from dealings between Wood and Rooney in or about 1990. That also did not induce Rooney to sell. Now, that letter of the 19th of September is a letter that is written by Mr. Brandt. And the reason why I know that is because it's in the bundle.
I'm sorry to interrupt my learned friend, but it's at this point that this is one of the documents that I was going to object to, which was, and then I was told do it at the appropriate time, and I do believe that this is the appropriate time. Firstly, this letter was not before the High Court. It was before the Court of Appeal and attached to Mr. Rooney's counter notice of appeal. At paragraph 27 of his judgment, Justice of Appeal Carrington explained why he wouldn't look at this counter notice of appeal, because it wasn't before the High Court. it wasn't put in evidence by Rooney at all, and it was too late to be put in evidence before the Court of Appeal. And indeed, there was no application by Mr. Rooney to adduce it under the rule in Nadd and Marshall, just as there is no application before the board to adduce this evidence under Ladd and Marshall. So it was never considered by either the Court of Appeal or indeed by the High Court. And I say, on that basis, it can't be put before the board.
Yes. Well, the counter notice was before the Court of Appeal. The counter notice was considered by the Court of Appeal. That's clear from the Court of Appeal's judgment. These were documents that were, in fact, annexed to the counter notice. Now, I don't invite your lordships to essentially take the view that because Mr. Brandt had been instructed on the 19th of September, in the light of the fact that there is a context to that letter of the 19th, including the fact that Mr. Rooney had essentially already intimated, look, this is my interest in this, I'm the director, that your lordship should make that finding. What I do say is this, that the fact that Mr. Brandt was not called to give evidence, and that the judge could not explore with Mr. Brandt, well, why didn't you conduct any inquiries? Precisely what did you know? In my respectful submission, that is relevant to the issue of whether the
issue depend upon the contents of this letter. I mean, you have that issue in any event, and the simple fact is they didn't call their lawyers. You've referred us to how the pleadings were interpreted by them as making the case that there was no improper inquiry, and they didn't call their lawyers.
Well, it was my submissions on the taking all of this evidence into account, taking the failure to conduct the inquiries as the judge found, which is remarkable in the circumstances, taking into account the failure to observe Section 107 and those safeguards that are there in order to ensure that the parties are protected. The failure to call the lawyers in order to give evidence and to explain what they knew, what they didn't know. But in actual fact, this is not just simply a case of constructive notice, that it justifies the decision of the board on the basis that the conduct of the appellants was actually unconscionable in my respectful submission. That's the submission that I make. Now, of course, if this evidence does not justify that, I accept that the submission on the basis of a constructive trust based on unconscionable conduct must fail. We then turn...
Just bear with me 1 second. May I take it then that you're not pursuing any application, or you're not asking us to look at this specific document in the light of the objection that's been taken and the observations that have fallen from the board?
My Lord, I say that it was in front of the Court of Appeal, and therefore it's proper for the board to consider it. But the importance of this of the document is not that I, as I said, I'm at risk of repeating myself.
The contents of the document as such don't matter, is that right?
I beg your pardon,
the precise contents of the document don't matter. You don't need us to look at the document?
The precise document, it does matter.
Certainly, let me say straight away before you go further. The board would be very, very unusual for this board to look at any document that was not before the courts below. And if this is a matter which is so material that we need to rule on it, then so be it. But if we've heard your submissions, and if you're content to proceed without us looking at the document, then that is what we will do.
My Lord, I am content. I am content for your Lordship to proceed. Your Lordship has my submission about the lacuna in the evidence, and I do rely on paragraph 7 of the board's decision in any event that shows that actually there had been a course of dealings between Mr. Cassell and Mr. Rooney going back some time, and that therefore in those circumstances that would have been material which the judge would have benefited from hearing from the lawyers acting on behalf of the appellants. And of course, I also say this in relation to the Allen appellants, that Mr. Markham was, of course, the person that acted in the underlying property transfer transaction.
Yes.
And we know that because that's the answer to a question Kenneth Allen, in his examination in chief, in answer to the question, actually said, Mr. Carl Markham represented us in relation to the underlying transaction.
On page 246.
Now, can I, if you're about to move on from constructive trust, can I just ask you, please, for at least for my benefit, to identify the authority which you say most clearly supports the proposition that in these circumstances a constructive trust arises?
My Lord, the circumstances, this is dealt with by Lord Brown Wilkinson at Westbush, and that, Your Lordship will find that at page 1422.
Thank you.
Of the authorities. Now, Your Lordships will appreciate that because we're not dealing with a trust, an anterior trust, or a fiduciary relationship, one can't have a case for knowing receipt, for knowing receipt, a constructive trust on that basis. Now, in my respectful submission, the principle that is set out here at C to G of page 142 of the electronic bundle, it's 705 of the judgment of the House of Lords.
Yes.
And it's the majority decision, in fact. And may I invite Your Lordships to just read paragraphs Roman numeral 1 to 5.
Yes.
And of course, if Your Lordships take the view that the facts do not support a finding of unconscionable conduct, that's the end. But this is the authority, and that applies even in the absence of an anterior a trust relationship or a fiduciary relationship.
So your case is that a void transfer plus unconscionable conduct of this kind equals either a constructive trust or, in any event, a claim in equity for the return of the land.
A constructive trust.
Well, oral personal claim, as the Court of Appeal found.
I don't have to go as far as unconscionable conduct for the purposes of a personal equitable claim. That's not what the Court of Appeal, that's not the way that the Court of Appeal justifies its decision. And the alternative way of justifying of essentially getting to a constructive trust is the way that that is posited by Goff and Jones. And that is on the basis of want of authority and lack of consent.
And that's the alternative to there being a constructive trust?
No, that is an alternative to unconscionable conduct. So we're dealing with a constructive trust on the basis of unconscionable conduct, or on the basis that on the way that Goff and Jones essentially suggests that a constructive trust may arise, and that is lack of consent, want of authority. And essentially, what the editors of Goff and Jones are doing is essentially using the principles of unjust enrichment in order to justify a proprietary claim via the constructive trust mechanism.
And do you have a relevant extract from Goff and Jones for us?
Yes, my lords. So, my lords, it's at page 1460. And I'd invite your lordships, first of all, to read 801, 802, up to expense. So,
halfway down 802.
So 802 up to 6 lines down.
Yeah.
So, your lordship. So 801 and then 802 up to 6 lines down, where it ends X, but at C's expense.
Yes.
Then 803, I'd invite your lordships to look at, read from this analysis all the way to the end. The editors put forward a number of conceptual obstacles, and the way that they deal with those obstacles. But I would now ask your lordships, if your lordships have read up to the end of 803, if I may, if your lordships could alert me when they have done so.
Yes, thank you.
Well, may I say this, that Goff and Jones are not the only academic writers that have posited lack of consent, want of authority, as a basis for an unjust enrichment claim, and also where in certain circumstances, the only effective way to reverse an unjust enrichment is through essentially the creation of a trust that it may well be possible to do so. And I'm referring, of course, my Lord Burroughs, I'm referring to your lordship's article in defence of want of prosecution, of unjust enrichment, I beg your pardon. That's page 18 and page 19.
Is that in our bundle?
No, it's not.
No. Oh, thank you.
And if my lords then look at 867 at page 1482. So here the learned editors of this work focus on Lord Brown Wilkinson in West Deutsch, and then over the page at 869. However, it's not inevitable that the trust identified by Lord Brown Wilkinson should be so narrowly conceived. His lordship's statements in West Deutsch must be viewed in the context of the view which he controversially articulated in the same case, that recognition of a trust depends on conscience of the title holder being affected, a criterion which might require some species of wrongdoing, or at least some form of knowledge of the trust justifying facts. If that is incorrect, however, then the trust imposed on a fief may be susceptible to explanation in wider terms consistent with the idea that C's lack of consent or want of authority alone might be sufficient to support an equitable proprietary entitlement in a two-party case, at least where exceptionally C's title has been effectively transferred to D without C's consent or appropriate authority, and where D is merely an innocent recipient. These cases are likely to be rare. Nevertheless, there are some cases that suggest the possibility cannot be dismissed out of hand. Then I'd ask your lordships to read 870 and 870 all the way to 872. In fact, 873 to 875.
Yes. Thank you.
My Lord, and just some further passages that I point out to your lordships. I'm conscious that I'm running out of time.
Yes.
And
well, you give us the passages. I think we've
yes,
got the
95,
sense of,
95, 96, 97, and 90. Well, in fact, all the way up to 102, where Goff and Jones refer to the cases of Relfo and Hampton Capital. Now, what I say about this as well is this:
I'm sorry, I didn't get the paragraphs. I do beg your pardon.
From 896.
896. Yes.
All the way to 102.
Thank you.
This is about personal claims.
Yeah.
And in relation to this, now, it's true that the normal claim for the relief for unjust enrichment is compensatory. However, where the only effective remedy or the only effective way of reversing the unjust enrichment is the return of the property, in my respectful submission, I've not been able to find any authorities to this effect, but in my submission, the submission I put to the board, that in actual fact, the court can make, even though that's an in personam claim, the court can make an order for the return of the property without making an order that the transferor has any proprietary right in the property. There's no reason, I have not been able to come up with a reason as to why the court couldn't, in those circumstances, just simply, an order couldn't operate in personam, rather than give the transferor a proprietary interest in the property.
What if the value of the land has changed substantially between the time when the cause of action arose and the time when you're thinking of ordering the transfer back of the land?
My lady, if we accept that in fact the unjust enrichment is founded on a lack of consent, impaired consent, or want of authority, that transfer should never have taken place in the first place. And therefore, in my respectful submission, it's not a relevant consideration to then say, well, the land has increased in value. The reality is that land should never have been transferred to the transferee in the first place. That's the way. But I emphasize that in this case, despite the Court of Appeal said, strikingly, there's no defence in relation to either any of the points made in the defence or the counterclaim. So a defence of, for example, change of position was never pleaded because nobody pleaded to that. Now,
mean, that would be the obvious. If you're going to go down an unjust enrichment route, you would immediately think, well, those purchasers have, in good faith, spent a lot of money. And you would want to recognise that in some way, would you not? Whether it's pleaded or not.
My Lord, none of that consideration came to the company, and we are left with here in a situation.
No, but that's not the problem, is it? It's with change of position, you're looking entirely at the defendant's position, which they changed in good faith.
Yes, but if that change of position, if that money is paid over in circumstances that we have in this case, where in actual fact not even the most rudimentary searches were undertaken, and all of that could have really prevented it, then in those circumstances the balance of equity, in my respectful submission, would be against a change of position defence. That's the submission that I make in relation to that. Now, my Lords, in relation to the Court of Appeal, now dealing with the personal equity. Now, your Lordships will have known, will have seen from our written case that Gibbs, we refer to Gibbs and Mercer. We've also set out the facts as well and the decision in Brelsford, both of which were relied upon by the Court of Appeal in order to come to the conclusion that there was a personal equity. Now, there is no doubt in my respectful submission that where a fraudster takes a property, even though if he takes with knowledge there could be a constructive trust, there's authority for the proposition that also there is a personal equitable claim as against that person, which then gives rise to a personal equity which entitles, as indeed that's the rationale for some of these Australian New Zealand decisions, it then entitles the court to make, or the court can then make an order for return of the property, not as an exception to the principles of indefeasibility, but as a claim in personam. That's when I originally made my submissions. Now, what has happened in this particular case is that the court essentially. Let me take your Lordships to the court's decision in Gibbs and Mercer, which your Lordships will find at 1217.
I think certainly, I know we've covered a lot of ground, but we do want you to reserve enough time to deal with Section 140.
Yes, well, my Lord, in that case, all I will say in relation to this is that.
The claim in personam, you mean?
In relation to the personal equity, we rely on the rationale of the Court of Appeal, the decision of the Court of Appeal plainly saw an analogue between this case and also the case again in Gibbs, the facts in Gibbs versus Mercer, where the board at page 257 essentially pointed out that if you're dealing with a company and you don't conduct the inquiries, then, or if you deal on the basis of forged documents, not a company, I beg your pardon, the basis of forged documents, you've got to bear essentially you bear the consequences.
Yes.
Now here, in circumstances where again there've been no inquiries that we know of, where quite plainly, at the very least, these appellants actually took with constructive notice, that we say is sufficient to raise an equity in favour of Pell, which would prevail when balanced as against the equity of the appellants, because of all the failures that we have covered during the course of my submissions. The reality is that if they had observed, if those lawyers had ensured that Section 107 was observed, they said, no, I want to see that. I want to see that.
We have your submissions.
Yes, you don't need to go over the submissions again. I think
So those are my submissions in relation. Now I turn to 140. May I ask your Lordships to turn to 140. section 140. My lords, the first point that we would make is that where it says knowledge, so it's subsection 2, knowledge of the omission, fraud or mistake in consequence of which the rectification is sought or caused such omission, fraud or mistakes, it's disjunctive. It's disjunctive. And essentially we rely upon the second part. So, or cause such omission, fraud or mistake or substantially contributed to it by its act, neglect or default. There is no doubt in my respectful submission that constructive notice based on the findings that the judge made at first instance is sufficient for a finding of this board that that any mistake has been substantially contributed to by the appellants.
Now, the mistake of the registrar in taking on these documents, or what mistake is it?
My lord, yes, it has to be. Now, may I take your lordships to Anton?
Has to be what, sorry?
May I take my lord to Antoine versus Barclays Bank?
Page?
This is at page 963, and your lordship will see. This is in relation to rectification under the 2002 English Act, and we pick it up at paragraph 14 at page 968. I'd invite your lordships to read paragraph 14. Your lordships will see that the provision is very similar to this provision.
Yes, thank you.
And my lords, then we turn to paragraph 39 at page 978. And your lordship will see at just below, between C and D, secondly, by way of corollary, whether an entry in the register is a mistake must be judged at the time that the entry is made. Does your lordship see that?
Yes.
I don't. What were you looking at?
That is between C and D. So paragraph 39 between C and D.
Yeah.
Secondly, whether an entry in the register is a mistake must be judged at the time the entry is made. And then at paragraph 44 and 45, paragraph 44, it seems to me that the distinction made by the textbook writers and by Kitchen Law Justice between void and voidable transaction is made because a void disposition is one which in law never took place and therefore should not be entered on the register. This is consistent with the approach in Argyll Building Society. That's also in the bundle, which was decided under the Land Registration Act 1925 and was a case in which there was a forged transfer. It was approved in the context of the 2002 Act by Kitchen Law Justice at paragraph 58 of his judgment. It is in this context that the reference is made to the knowledge of the registrar in an entirely abstract sense. Had the registrar known that at common law the disposition did not take place at all, and accordingly there was no disposition for him to register in his administrative capacity, he would not have done so. There was a mistake at the time of registration because in law there was no disposition to register. Now, of course, pausing there. Essentially, these appellants, in my respectful submission, substantially contribute to this situation because they never made the inquiries.
Let's don't just jump to substantial contributions. So, this is what you rely on to say that what is the mistake and who has made the mistake? Can you just explain?
The mistake, and it's paragraph 45 as well. I'd ask your lordships to look at that as well. But
so the mistake is the mistake of the registrar.
The mistake is the mistake of the registrar in essentially registering a void disposition. Now here, the reason why that void disposition actually gets to the registrar in the first place is, of course, because none of the inquiries are essentially made by any of these by any of these appellants into the authority that the directors had, Mr. Cassell had, to represent the company. And indeed, all the other ways in which I've already taken your lordships to as to non-compliance with section 107, etc.
It does require a broad interpretation of the word mistake, doesn't it?
It requires a broad interpretation. I accept that. But this way of analysing this issue has also been the way that.
But it seems to go back to the 8th edition of the Law of Real Property, Rolfe and Roper, and the consultation paper of the Law Commission in 2002. Is that right?
All of that is in relation to background, but this is very clear in terms of the registration of a void disposition. You register a void disposition, it should not have happened, that's a mistake. The question then is, have the appellants substantially contributed to this by essentially allowing a void disposition to go forward?
Yeah.
Now, my lords, we also look at Lucien, the Lucien case, which is at...
Just before you go there, might you an alternative, or are you making the alternative submission that you could rest the argument on fraud as opposed to mistake, in the sense that clearly here there is fraud, that's not in dispute, and that the fraud has been substantially contributed to by the neglect or default.
That's the way that Mr. Rooney put it, and I don't resign from that. I put it in that basis as well. We have added, for the purposes of the cross-appeal, the alternative basis based on mistake. That's what we have done in our written case. Mr. Rooney has always said, look, you fall within section 140 because of those reasons. If I may take your lordship to page 1222. So this is a case, it's a Lucia case, Silvina and Lucien versus Jacob.
We're going to have to ask you to wind up in the next few minutes, so could you please absolutely focus your submissions and tell us
the passages
to look at, submissions you want to make in relation to them, as opposed to...
My lord, it's exactly the same submissions, and the paragraphs, your lordship will see paragraphs 41 to 44.
Yeah.
I invite your lordships to read that.
Yes. We made a note of that.
Yes. And Webster versus Fleming, which is at 1378. And that's paragraphs 52 to 55. And this latter case is a case where essentially what was being registered was an adjudication that was ultra vires in actual fact. And we see that from paragraph 55.
I must have misunderstood your reference to Lucerne. I've got, did you say page 1022? No.
So Lucerne is 1222.
Thank you very much.
And that's paragraph
41 to 44. Yeah.
44. And then we have Webster versus Fleming.
Yeah.
And that is a Anguilla case. And it's paragraphs 52 to 55.
Thank you. And that's referred to, I think, in the Louisiana case.
Yes, it is.
So
Yes.
how does this work, though? Suppose you're right, and because this is a void transaction, the registrar made a mistake, the appellants substantially contributed to it, so it's rectified. How would that affect the subsequent title if the appellants had sold this land before now?
It would have been, Mr. Appel would have lost any right to come before the court in relation to that land. They may still have had a personal claim in certain circumstances against the appellants. They may have.
I know. I'm just talking about the right to rectify.
There would be no right to rectify if the property if essentially these appellants had transferred the property. Is that what you're on?
Yes, I'm talking about this rectification claim, how it would work if there was the land had been sold on, whether or not whoever was in possession of it still.
Well, it depends whether in relation to that transaction, in other words, that appellants to a third party,
Yes.
there is then a mistake that comes, or potentially fraud that comes within.
Assuming not.
Well, my submission, I think that my learned friend, my junior, doesn't agree with me in relation to this, and I'll allow him to. I can't see how Section 140 would be applicable in those circumstances. In relation to the original.
I'm afraid we're going to have to invite you to close your submissions.
My Lord, essentially, what we say on Section 140 is that, just based on the findings of the judge, there's no doubt in my respectful submission that the appellants have substantially contributed to the mistake, and that therefore the Appell is entitled to rectification of the register under Section 140. It actually is a very simple case in respect of 140, we say.
Can I ask just one very brief question? And that is this, that in relation to your personal claim, you're relying upon a decision, Brelsford, which is the High Court of Australia. And presumably that is not applicable in the law of Montserrat, unless it's also applicable here.
If your Lordship...
Can't just import into the law of Montserrat a concept from Australia and say, well, there you are, that's a separate area, and Montserrat can have their law, and they can pick Australian cases if they want to. It would have to be a concept that would read across into the law of the United Kingdom.
And the underpinning that decision is, of course, our equitable principles. If there is no... If essentially... that the decision cannot be justified on equitable principles or equitable law as we know it, which I accept would be the law applicable in this regard to Montserrat, then if there's no crossover, there's no crossover. We say there is crossover.
Thank you very much.
Apologies, it's taken me longer than...
Mr. Garrett.
Can I reply just very quickly? I'm conscious of the fact that we're over time, but can I start on the...
You have time. You make your submissions in reply.
Can I start with the Section 240 point?
Yes.
Substantial contribution. The mistake commences with the court in Montserrat in ordering restoration. It's then followed by the Register of Companies in registering Pell. It's then followed by the Registrar of Lands in registering Pell in its new form as the proprietor of the land. And it's compounded by the Cabinet, headed by the Governor, who grants 2 landholding licences to Brelsford and Kraus. And we say the blame lies not only with Mr. Castle, but substantially with the government and government agencies. That's the first point I make. The second point I make is that so far as constructive trust is concerned, this is not a case where there is any unconscionable behaviour by the appellants. Each of the appellant paid substantial sums for the land in question. Neither is there any unjust enrichment on the part of the appellants, because the appellants paid, in my submission, fair value for the land in question. What the respondents seek to do is to say that there is a new category of personal claim wherever a void transaction takes place. Then there is a personal claim and, as it were, almost an absolute right for the old proprietor to obtain rectification. I respectfully submit that that is not the law in Montserrat. That is not the law in the Eastern Caribbean. And if that is to be the law, then it in effect destroys the Registered Land Act in Montserrat and the other Eastern Caribbean territories. What we have here is an unfortunate case where Mr. Castle has caused serious difficulties, not just with these appellants, but other purchases in Montserrat. There are some 16 other cases waiting in the wings that are dependent upon this. And we say, particularly in the case of Krause, the Krauses who were on holiday, came on holiday, saw land, left it to their real estate agent to deal with it with an attorney. It's wrong to say that they were unconscionable. My Lord, so far as the Court of Appeal was concerned, the Court of Appeal accepted that these appellants were innocent purchasers. They didn't accept there was any unconscionability at all. And even though Mr. Rooney had pleaded that in his claim, in the counterclaim for Pell, that was firmly rejected by Justice of Appeal Carrington at paragraphs 27 to 28 of the judgment. That should be at 301, when he held that the counter notice of appeal was not suitable for consideration. And he says on the last two lines, with respect to the issues of fraud, these were not supported by evidence in the court below and were not proven. The respondents are not able to raise them before this court. So that finding made by the Court of Appeal is the finding effectively that the respondents wish to go behind, and I would submit there is no evidence to support it. It's difficult for the appellants to say what was going through the minds of Mr. Brandt. Mr. Brandt dealt with Pell at one stage, but certainly Mr. Markham didn't. And Mr. Markham sadly has died, but no lawyers gave evidence. So what you're being asked to do is you're being asked to infer that on the evidence that these were all deliberate actions on the part of the lawyers without it even being put in the High Court. And I say that is not an inference which can be reasonably drawn from the evidence before the board. And my submission is that if there is an in personam claim, it has to be based on either contract, trust, a fiduciary duty, or fraud. I say there's no fraud on the part of the appellants. There is no trust on the part of appellant, particularly a constructive trust, and there was no contract between the appellants and Pell. And in those circumstances, I did go back, I don't want to repeat myself on this, but I go back to the fairness of the decision that was reached by the Court of Appeal without considering the evidence on both sides to see where the equity lies. But unless I can assist the board any further, those essentially are my submissions in reply. There's one more thing I do have to say about, we didn't quite go through the documents, but there's an affidavit by the Registrar of Lands, which the other side wanted to rely on, again, which wasn't before the Court of Appeal, sorry, before the Court of Appeal rejected, wasn't before the High Court, and I'd ask you not to look at that.
Well, I think ultimately we haven't been taken to anything that was not before the Court of Appeal which you object to. We haven't been shown anything.
Yes. And I simply ask the Court to say there was fraud by Warren Castle, but not by the appellants. Unless I can assist the board any further, those are my brief submissions in reply.
Thank you very much indeed. Thank you all very much for your submissions and for and also to those assisting you for preparing the papers. And we have covered a lot of ground, some of it very quickly. We will obviously need time to reflect on your submissions made to us today and in writing. But the board will give its decision as soon as it can in the usual way.
Yes. Thank you.
Thank you very much. We now adjourn.